Okay, welcome to another episode of what is now known as the Litigious Podcast. We're in a rebrand here because we talk about litigation, we talk about lawsuits, and that's what we're doing. So, if you came here for Talk Lex, you're in luck. You're in the right place. But we are rebranding as the Litigious Podcast, and so. We look forward to talking about lawsuits more frequently and answering questions about lawsuits, which we get all the time from friends, family, and everyone else. Um, so, Giovanna's here. Welcome.
Thank you.
We're talking this week about all kinds of stories involving it ends with us litigation between Justin Baldoni and Blake Lively. It is the lawsuit that is probably the most well known at the moment, all over the news. We've gotten a lot of questions about the Diddy criminal proceedings in New York. We are not talking about that yet. We may talk about that at a later date. At a later date, we'll also talk about the recent allegations of sexual harassment made by prominent podcaster Alex Cooper from the Call Her Daddy podcast, which sort of falls within our wheelhouse in terms of our legal practice. But today we are focusing on the most recent updates in the Baldoni-Blake Lively case. And there's sort of two things to talk about, I think. Let's start first with chronologically what happened first, which was Blake Lively made the decision to withdraw or discontinue a couple of her claims against Baldoni and the parties relating to intentional infliction of emotional distress, among potentially others. Um, Not surprising from our perspective, but why don't you kind of get into the specifics of that, and then we can talk about why she probably did that and the conversations we have with clients all the time.
Yeah, so this recently popped back up in the news. I mean, it's always kind of out there here and there, but this is one of those lawsuits where every single little procedural thing that often is really no big deal kind of gets reported in the news like it's like something super significant. So Blake Lively, the first thing that came out in the news recently was that she had dropped her I think she dropped her claims for intentional infliction of emotional distress, but then she also, I think, dropped her claim for emotional distress damages as well. Um, and that was reported as being kind of significant because I think that, obviously for clickbait and this, has like, there's a million people on Threads and I don't know, I'm not on X, but maybe on that too, and Instagram that are like, have devoted a lot of their little podcasts and things on like little snippets of commentary on this lawsuit, as have we, I acknowledge. And so everything that happens comes out and it's made a big fuss about, and I think is painted as potentially being more significant than it really is. So I think when that came out in the news, it was being sort of represented in a way that almost like a win for Baldoni. Like, this is significant that she dropped this. Maybe she realized like this is a terrible claim or something like that, like something really significant. So I looked up the docket of this case, and what appears to have happened is that, and I think we talked about this on one of our prior podcasts, one of the pitfalls on the plaintiff side in employment cases is when you claim emotional distress, depending on what level of damages you're alleging, your medical records become something that can be exchanged in discovery. This can be a huge deterrent to pursuing a significant amount of money on a claim like that, because most people do not want to have their therapy records read by their adversary and their adversary's lawyer, especially in a case like this that's super contentious. So my perception when this came out was that that is why she dropped those claims, so that she could avoid producing her medical records. And just from looking at the docket and the letters that were written and the judge's order, um, I think that's what happened. Like the Baldoni's people were trying to get the medical records and, sort of in response, Blake Lively's, said, we're just going to drop all these claims. Now the medical records are not relevant, so you're not entitled to them. I think because this case is so public, when Blake Lively's attorneys wrote to the judge about it, I think they tried to spin it a little bit differently, that they felt that they didn't need those claims because they were going to collect their damages in some other way. But I think it was, probably genuinely just to avoid having to give, any medical records, which is super invasive.
Yeah, we we see this a lot, and like you said, it's we always tell clients when you file a lawsuit, and especially when you claim emotional damages, you are an open book. And people, I don't think, realize the extent to which that's true. And especially in a case like this, my guess is they smelled blood in water, and probably a smart tactical move by Baldoni's folks pursuing it aggressively because they probably knew that she had no interest in getting these records out. And I mean, just put yourself in the shoes of somebody who's a celebrity who's got this, quote unquote, perfect marriage with another celebrity. Um, who knows what's in her therapy records, but if there's any reference to marital problems, other, mental health challenges, these people would jump all over it and it probably would make its way into the public. So she's got a lot to lose by doing that. And so it's not at all surprising to see, that claim dropped. What's interesting is that they're trying to Baldoni's team is still trying to get the information, which at this point is completely irrelevant. And, bordering, well, it seems like it's completely irrelevant. They're probably not going to be entitled to get these records or question her about that, I assume, since she's dropped the claims. We've had that happen in cases before where, the claims haven't been pursued specifically because we didn't want to get into those waters, and we won't let questions come about it.
Yeah, I mean, you have to make a decision with your client about, is the emotional distress stemming from the incident that you're complaining about such a significant piece of your damages that it's worth going on that road. And sometimes it is. Sometimes somebody has never treated for mental health issues in their life, and then something happens to them at work, and now they have PTSD and all this horrible, like mental health, damages from that. And in those cases, it's worth pursuing that claim because it's a significant piece of it. What becomes more difficult is if someone has been treating or going to therapy or whatever for, a long time, and they have other traumatic things that have happened in their past, and they also have emotional distress from what happened in their lawsuit. But in that situation, you have to kind of weigh with your client, do I want to go down that road where they are going to be entitled to see these other horrible things that have happened to me in my life? And we've definitely had cases where, that we did go down that road, and it's our responsibility to protect our client as much as we can with confidentiality agreements and protective orders and redacting information that's in those records that is very, too personal and also not relevant. But it's definitely a consideration. And when we are thinking about making that type of claim, we obtain and review the medical records first, because you cannot be in a situation where someone is going to be entitled to look at medical records that you've never seen before, and that you haven't had the opportunity to try to protect your client in there. So I think ultimately in this situation, they decided it's not worth it. It's too public. Even if they had confidentiality and protective orders, I think that the way Baldoni and his attorney have kind of treated this case, like creating a website where they're posting, it's just like stupid stuff. In my humble opinion, I would be very afraid to put anything that was super personal out there in the universe, because yeah, you can go to the judge and get somebody sanctioned for violating a protective order or something, but once it's out in the world, like, and you're a public figure like that, like you can't unring the bell. And then intention, just as also as a side note, I don't know if we touched on this in another podcast, but the claim for intentional infliction of emotional distress in New York is like a very, very difficult claim to prove. The standard is very, very high. I don't know that, we really never include that claim, like every once in a blue moon, usually when someone's been physically assaulted. It's just a really hard standard. I don't know that, she needs a claim like that necessarily, or that it would be successful. The most recent thing I feel like I've seen in the news that I felt like would lend itself to a claim like that, because the law hasn't necessarily caught up to like what other type of claim would I make, is that what's that guy's name? McAfee.
Pat McAfee.
Right. When he was talking about that poor college student, like it's kind of hard to figure out like what would be a legal claim in that situation, like maybe defamation, maybe something else. I felt like, oh, this could be one of the few times where an intentional infliction of emotional distress claim could be potentially like a tool to hold someone accountable in a situation like that, like a harassment situation where you don't really, or like a cyberbullying situation where maybe you don't fall within like a statute or a specific cause of action. That's where something like that can kind of come in. So that was the first thing that was in the news. So before we spend too much time on that, there was something more significant development in this case that came out like 2 days ago.
Yeah. So all that happened, and then news broke that a judge had dismissed the majority of Baldoni's claims in a $400 million lawsuit. And that is obviously much more significant than Lively discontinuing some of her claims. So the decision is 132 pages long. I've not read the whole thing. I did read some of the relevant parts of it. It's clearly well thought out and written in a way to that was probably expecting that it was going to be read and poured over. So why don't you kind of explain what the decision said and kind of where that takes us? Because it obviously operated on a number of legal claims, and the media has spun it, and Baldoni's people have spun it in an interesting way. So we'll talk about that after.
Yeah, so this is pretty significant. So Baldoni commenced his own lawsuit, which is kind of consolidated with Blake Lively's, where he alleged a bunch of contractual types of issues, as well as defamation against Blake Lively, Ryan Reynolds, the New York Times, based on the New York Times article that came out at the very beginning of this whole thing. I think he had people from Marvel in there. So it was kind of like a kitchen sink complaint against a lot of different people for a lot of different things. And if people have been following along, we did have an episode where we talked about this, and one of our sort of takes on his lawsuit at the time was that it felt very convoluted, and it really felt just like a narrative with the intention of just getting his side of the story out about how, not nice Blake Lively and her husband are, and how they, screwed him with this movie and taking control of it and this and that. But like, what are the actual legal claims here? So when you read the decision dismissing the vast majority of that lawsuit, I think you get the vibe that the judge did not really like his lawsuit. I don't think he liked the way the complaint was written, like this big narrative of grievances. It had an exhibit attached to it that was also like this huge narrative of grievances that I think the judge just said, I'm not even looking at this. And ultimately, what happened is the judge dismissed all of the defamation claims. It dismissed a California law extortion claim, and it dismissed but is allowing an amendment to some contract based claims. But the New York Times is like out of the case now. I think the Marvel people, Ryan Reynolds, I think are out of the case. Maybe they might come in on the breach of contract or some of the contractual types of issues where that he's alleging that they might have interfered with his relationship with his agent and things like that. But for the most part, the case has been dismissed. And probably in terms of newsworthiness, it's the defamation claims that people are going to feel like are the most significant of a loss for him, because he's alleging that the New York Times article was false, or at least, misleading enough to fall within the realm of defamation. And the court said that you have not adequately pleaded that. Not only have you not adequately pleaded it because your complaint is a big mess and you really didn't identify what was false and who said it and who said it about who, but also because most of the New York Times article was based on a complaint that was made to the California, civil rights agency, and that is privileged. Meaning that, in the law of defamation, there are certain types of statements that have a in litigation, it would be an absolute privilege, which means that you can basically say kind of anything in some ways in the context of a legal proceeding, and you cannot be sued for defamation.
Yeah. And it's interesting for a couple of things. So, first of all, claims against publishers like the New York Times for defamation are notoriously like the most difficult claims to win. Defamation cases, we've talked about this before, are very difficult to win in general. I've been involved in defending them over the years. We don't typically take them on the plaintiff's side because they're almost always too hard to prove. The law is very favorable to the entity in these cases. Not only that, but when you have a public figure, the standard is higher. But this was, I think, well played, and I don't even know if it was intentionally well played by Blake Lively's folks, in that they had prepared this complaint to be filed with the California agency. My understanding is it hadn't even been filed yet, but because they intended to file it, it was privileged. But it seems from the decision that it's pretty clear they probably leaked that complaint to the Times, and the Times ran with that in their story as part of the allegations. So if that is in fact how it played out, I think that's a smart move. They probably had the protections either way, but that certainly bought them like an extra layer of protection according to the judge's decision, right?
Yeah, and I think the judge was applying, it's like a little convoluted. So one of the reasons, and we touched on this in one of our prior episodes about this case a little bit convoluted because of the mix of California and New York law.
Yeah.
That's one of the reasons why the decision was so long, is because you have to do this whole choice of law analysis in these types of cases. It's very boring. It's something you learn about in law school. It's like an argument you would prefer to not have to get into in a lawsuit. But half of the 100 pages of this decision have to do with figuring out which law applies. So they applied California law to the claims against, I think, Blake Lively, and they applied New York law to the claims against the New York Times. So California law, and I think the California law still kind of like stepped in when the New York law was applying in terms of the privilege. So California is very protective of complaints that are made in this kind of like sexual harassment context. So in addition to their litigation privilege and their administrative proceeding privilege, they have another privilege that's in their California statute when it comes to making complaints of sexual harassment and things like that. So ultimately, like, even though she hadn't filed it yet, the judge still considered it to be privileged. And ultimately it was filed, and then it was the subject of a lawsuit anyway. So the court basically said that, her claims here are privileged. She can't be sued for defamation for making them. They're made, there was no proof that they were made in bad faith or anything like that. Her claims, obviously in every lawsuit, there's a completely opposite side of the story. That doesn't mean that what you're saying is defamation. It just means that somebody is entitled to make their own side of the, make their own claims and dispute what you're saying. And then, maybe they'll win and maybe you'll lose. When it comes to the New York Times, same thing. They're allowed to review a legal document and report on it. And that's basically what they did. What they did that kind of went a little bit beyond the legal document was reporting on the text messages that demonstrated this smear campaign. And Baldoni is kind of saying, these were misleading. They were sort of taken out of context. And the judge was kind of like, yeah, that's what, like, That's what every lawsuit does. You take the parts of it that are good for you and you use that and you spin it to help your client. And then the other side comes in and they add all the contacts and they say, well, that's like not what really happened. And you could tell like throughout the decision that the judge was sort of like, even when it came to the extortion claim with all of this, creative differences, issues that came up in the post production of the movie, the judge was kind of like, yeah, like this is what happens, it's not nice, me. I don't necessarily feel like the decision made Blake Lively look so great because um I guess a footnote to this is procedurally, this is a motion to dismiss. So a motion to dismiss is directed at your complaint and the allegations in your complaint. It doesn't look at any evidence. It only looks at, I'm looking at this complaint and are the allegations in this complaint sufficient to plead a legal cause of action? And when the judge does that, they take all of the allegations in the complaint as being true, the factual allegations. So she doesn't necessarily look great because all the facts in the decision are against her because it's taking what he's saying as being true. But the judge is still saying, I'm sorry you didn't like what she did. Maybe we all think she's nasty and mean and they did the wrong thing, but that's not illegal, you know?
Yeah, and I suppose to the extent that that was his goal, it's sort of mission accomplished. And, getting out his side of the story, which he did, getting out the side that says that these people are not, as shiny and happy as you might think. But in the end, so the judge left room for them to amend these contractual claims that you were talking about. And their lawyer is now spinning it as, this isn't even a victory for them. We're going to refile these claims. We can pursue these claims. But the reality is that in all likelihood, it seems like the contractual claims are probably significantly more limited. They are much less flashy and splashy. And he's probably lost a fair amount of leverage on his side in terms of, this potentially $400 million massive counterclaim. That's my feeling.
Yeah, I mean, he has like, I mean, obviously everybody in this case has deep pockets, but you lose like a deep pocket defendant in the New York Times. I think the Marvel studio was in there. It's definitely, I think, a win for her in the context of the lawsuit. Like you said, the damage in many ways has been done. I mean, I've noticed that she has kind of like come out of her hiding. I think she did kind of put her head down for a long time, as I would advise someone to do in any kind of lawsuit, even if you're not a huge public figure. It's like while you have your case pending, you kind of put your head down, you don't talk about it. His side has taken the total opposite approach on that and has been incredibly vocal, but I think that's because he really is trying to save, his reputation. I think the damage has been done to both of them. I think because she is probably more of an A-lister than he is, as well as her husband, I think it will probably ultimately blow over more for her. Um, because you can see that she's kind of back out. Like she had another movie come out. It was like, I think pretty successful. That Simple Favor. I remember the first movie I really liked. So, she's a little bit, I think, more in that movie star kind of role where I think, ultimately people will get tired of this and she will, I saw her, she was just recently at like a Chanel event for the Tribeca Film Festival. Like, I think she's coming back out and just sort of, and then she has, this sort of vindication to a certain extent of, on her side, you can spin it that when a defamation case is dismissed, you can say that means I wasn't lying.
Which
You
not
know?
is actually not what the decision says, but you can certainly spin it that way. Um, yeah, this goes back to I still think this is a case that in the end, I don't think it's going to be some big splashy trial. His side seems to be losing steam with his decision. I think your point about her and their side is probably right. They probably, or I would imagine they view this as we can move on, move past this. And the more this is in the media, it ultimately is not helpful for her. So I said in the beginning, I thought this was going to get settled at some point. I know you didn't agree with me. I still think that. I still think that they have an incentive from her side to make this become less and less public. And if they've got some leverage, I think that's probably what they'll pursue. But maybe I'm wrong.
Yeah. So I listened to just a little snippet of Good Morning America yesterday, and Dan Abrams was on, and I was like, oh, remember?
Yeah.
Like, so Dan Abrams, in case people don't know this, is like a legal commentator, but his father is Floyd Abrams, who is like the biggest First Amendment, if he's still alive, I'm not actually sure, but is like the biggest First Amendment attorney ever. And I did my summer associate position at his firm in Manhattan when I was in law school. I didn't work with him because he would pick only one associate or a summer associate from Yale, which I think was his. You had to be from Yale because that was where he went. And that would be like his, summer associate. So anyway, but I did go to a cocktail party at his very fabulous apartment. So anyway, I saw Dan Abrams on Good Morning America yesterday, and he said that he did think that if the case would settle, this was the moment. The reason why I'm a little skeptical about settlement is really because of Baldoni and his attorney. I think if you're it like other people, like yes. But I really don't know in this situation. I think he may, if he doesn't have an attorney checking him, which it doesn't seem like he does, I could see him being willing to sort of like fight to the death over this. Um to try to save his reputation. And I went back and listened to some of our other episodes about this just to kind of refresh my memory as to like where this was at. And I do think her case on liability is difficult. Like not only on liability, but well, this would be part of liability, like the causation of even if this smear campaign happened, did it happen because I made a protected complaint of sexual harassment, or did it happen because we had a falling out over who got to be the ultimate decision maker about this movie? So I think her case is not going to be super easy. I don't think. Um, that doesn't mean she won't prevail, but I don't know. I'm like I kind of feel like the personality of him and his attorney might prevent them from settling it because people will spin, at this point with all of his claims basically dismissed, if they settle, it's a win for her.
Yeah.
You know what I mean? If the case settles while they all have all their claims in, then I think you could spin it like we're mutually deciding to avoid the trauma of moving forward with this. But now that his like most splashy claims are out, and the judge didn't even give him the chance to replead the defamation claims. Those are like gone forever unless he appeals successfully. Um, I feel like a settlement, especially now after his claim was dismissed, if they settled in any close proximity to that, I think it would be very hard for them to spin it in a positive way for him. He'd be like coming back from a loss. And my vibe of like his ego and his attorney's ego is that they would not allow that to happen.
Yeah. First of all, Floyd Abrams is alive. He's 88 years old. He is the still senior counsel at Cahill Gordon, where you spent
Oh
the
my,
summer.
I'm sorry
So,
about
no,
prematurely.
and I would bet he's an avid listener of this podcast, so I think you owe him an apology. Um, yeah, look, I reading the letters from Blake Lively's attorneys, Wilkie Farr, which is a very serious law firm. It seems like Baldoni's lawyer is like firing off messages, emails like all hours of the weekend saying that they're not responsive because they're not responding like in the middle of the night on a Saturday night. The guy's obviously a pit bull. I get it. I'm not saying it's going to settle now. I'm saying that my prediction holds true that I think that ultimately it settles. I think smarter heads will prevail eventually. Maybe
And I
not.
think she has an incentive to settle it as well. I'm just saying I don't know if they have the same incentive
Yeah.
necessarily. I mean, if I were her, like, do I want to give a deposition to this guy? Probably not. But I mean, you have to go into the lawsuit knowing that you're gonna have to do that.
Yep.
You know, do I want to be like in a public trial with somebody who's clearly kind of like a showboater? Now, I really did get the vibe from the decision that the judge might not view, aside from dismissing the cases on a purely legal basis, I think there's enough in there to give the impression that the judge might not view his case very favorably. Um,
Yeah.
because I don't think judges like convoluted things to begin with. And one of the reasons why one of the various different grounds for the motion to dismiss was like a purely procedural federal rule of civil procedure, like pleading defect, which in layman's terms, it was basically like this complaint is a big mess and we can't even figure out like what the claims are and who they're against. So you know, good courts don't like that. You know, especially federal court, you're in the Southern District, very serious. Um, I don't know. I mean, you know, we're not some massive national law firm, and I think we take like a lot of care in our pleadings for that reason. You know, you don't want your pleading to be open to dismissal. I find that to be like, this is,
Harris.
to me, this is like embarrassing to have your complaint dismissed on a motion to dismiss
Yeah, I agree. I agree.
when they're taking everything that you said as true, and you get like all the case law that's like, we take it, you know, we have to view this in favor of you and in favor of not having your complaint dismissed, and you still get dismissed.
Yeah, I agree.
But I think it's hard. I mean, when you have a litigation privilege, you know, that's a tough, very tough defamation claim to make, especially when you're a public figure. Then you have to prove and plead in your complaint actual malice. And, you know, you're reading this New York Times article. They clearly did their homework. They're looking at text messages that exist. They're looking at a complaint that somebody else made and they're reporting on it. You know, I think the judge was like, there's no proof, or there's no, not even an allegation here that would support, you know, an inference that this is either false or that this was reported with actual malice. And he pointed out parts of the New York Times article that actually were sort of against, you know, Blake Lively, and did try to paint it a little bit more fair. And ultimately, like when I was listening back at one of our prior episodes to refresh my memory for this, the article is really more about like it uses this as the example, but it's really about like the digital age and how you can take people down using these crisis PR firms and using social media and things like that. So I think that just I think this was like a very difficult claim to ever make.
Yeah, the irony, making the a defamation claim against the New York Times, which is one of a handful of media outlets that still use like editorial oversight in their reporting process when, you know, you can go anywhere online and find thousands of claims that are just completely not researched or vetted in any way. And, you know, you're suing one of the publications that arguably still takes that seriously. Now, I know there's criticism of some of the stuff the Times has run over the years about recent years about, you know, whether they've lost their editorial standard. But I think it's, you know, of all the publications to sue, that's probably not the best one because they probably did, you know, they checked their dotted their I's and crossed their T's before running an
Yeah,
article.
and one of the journalists who wrote the article is like, she blew up Harvey Weinstein. I mean, this is also, like you said, I mean, people might criticize any sort of big media outlet or newspaper, maybe when they're reporting on more political issues or partisan things. But these people, and I don't know if the judge even said something like this or if I read it in a different article about it, but like, why would the New York Times make up a story about Justin Baldoni? Like,
Yeah.
who even knows who these people were really very much, unless you like were a big fan of Jane the Virgin or something like that. Like, I think maybe it wasn't the decision. I feel like it just was sort of implausible that they would be trying to make up an article
Yeah.
about, spread lies about these particular people. Like it's not in the scheme of things like the most significant situation on the face of the earth. Like I respect her for calling him out and pursuing the legal process and putting herself out there, if in this context, because she definitely opened herself up to a ton of criticism. But that being said, it's not like the most, horrific like expose of disgusting behavior that we've ever seen in our lives that would, support this idea that, an organization like the New York Times is going to do some defamatory article about, somebody who a lot of people never heard of until this blew up.
Yeah. Yeah. I completely agree. All right. I think we should wrap it there. Anything else before we do?
No.
Okay. Um, all right. Well, thanks for listening. We'll be back soon. Next time we'll talk, like I said, we'll talk about the Alex Cooper allegations. Maybe we'll talk about the Diddy trial, depending on where it is, and any other questions that anyone has. So if you like this podcast, please subscribe, leave a 5-star review, and thank you again for listening. We'll talk with you soon.
Bye.